Welcome to Case by Case. This is a podcast brought to you by Zyler Floyd Zadkovich. You have Calum Cheyne, and today I am not joined by Luke Zadkovich. I'm joined by Miguel Caballero, a senior associate in the London team. Welcome to the podcast, Miguel.
Thank you, Calum. How are you?
I'm very well. It's great to have you on. And I think this is your first appearance on the podcast.
It is indeed. It's a pleasure for me to be here with you today.
We're delighted to have you. And we are talking about classic shipping law 101, if you like, speed and performance claims under a time charter. I don't know how many of these you've seen in your career, Miguel, but it is a regular issue under time charters where a vessel is not performing in accordance with the warranted speed and the warranted bunker consumption.
Yes, indeed. It is a classic dispute. I've seen quite a few in my career, and I'm pretty sure that many of our the people in our audience would have faced similar issues in the past as well.
And there are a couple of interesting points in this decision. We're looking at a London Arbitration award. As our regular listeners will know, and as practitioners will know, these awards are non-binding, but they are typically helpful authority in future arbitrations. This is London Arbitration 923 from the Lloyd's Maritime Law newsletter. And yeah, as I say, there are a couple of interesting points here around, firstly, the LMAA small claims procedure, which could be helpful to any of our listeners who are working in a role where they deal with that procedure for some of their smaller claims, and also on a clause that you see often, I find, in speed and performance clauses, which says that the any disputes are to be resolved by referring them to an independent weather routing bureau. And how should a tribunal deal with a situation where that's not been followed? But I wondered, Miguel, if you can just give us some background to the dispute. How did the parties end up in arbitration?
Well, the owners and charters were involved in a dispute over essentially final hire accounts, and they decided to refer to LMA arbitration, as you said, under a small claims procedure, in this case 2017 terms. Owners saw outstanding hire payments, and charters made a counterclaim for damages related to a speed and consumption issue. So essentially, charters had the claim, and essentially they didn't pay outstanding hire, and then prompted owners to initiate arbitration proceedings against them.
That's a situation that we see reasonably often in these charter party disputes, whether it's off-hire disputes or speed and consumption disputes or any kind of dispute around the charter, where at the end of the charter, charterers basically withhold the hire, and owners then are the ones that have to bring the claim. But the claim is very straightforward. The claim is basically, we think that hire ran for this whole period, you've not paid us for it. And then it's the defense and counterclaim submissions from the charterers that are more in depth and basically take the role of the normal claim submissions, where they say, the reason we've not paid you is because we have this claim.
In this case, there were some minor discrepancies in the final hire statements presented by both parties. But yeah, you're absolutely right, Calum.
And that's another, everything about this case is really kind of classic charter party dispute. Even those kind of small discrepancies that you see when you're going through the final hire statement and you're trying to work out why the numbers don't match between, your claim is X amount, but the difference on the final hire statement is Y, and trying to make X reconcile with Y is normally a sign that there are some other smaller issues, which was the case here, and had the effect of limiting the claim or indeed the counterclaim. And the first argument that owners raised was a bit of a novel one. I hesitate to say it was a try-on, but it was not the best claim that the LMAA will have ever seen, essentially trying to argue on a procedural point that charter's counterclaim was time-barred by the language in the LMAA small claims procedure.
Yes, indeed. Owners said that the charter's counterclaim should be dismissed because subparagraph 5G of the small claims procedure rules said that if a party failed to deliver the letter of submission within the specified time, then the arbitrator would have to notify the defaulting party, and should the defaulting party fail to file its letter of submission within the deadline set by the arbitrator, then the tribunal could, in principle, proceed to an award based on the existing submissions and documents. In this case, owners contended that the use of the phrase must be in the rule indicated that the charters were under an obligation to submit their claim within the set time frame. And since they had failed to do so, the counterclaim then should be considered time barred.
Exactly. It's a very good summary, if you don't mind me saying. And 5G, just to give our listeners the wording there, it says any extension to the above time limits must be applied for before expiry of the existing time limit. If a party fails to deliver the appropriate letter of submission within the time limit set, the arbitrator, on the application of the other party or of his own motion, will notify the defaulting party that unless the outstanding communication is received within a fixed period, maximum 14 days, he will proceed to the award on the basis of the submissions and documents before him to the exclusion of all others. And it seems to be the case, and as is often the way with these London arbitration reports, they're kind of short, they're intended to be punchy, usable for practitioners, but you don't have the detail that you would see in a high court judgment or a court of appeal or Supreme Court judgment. And what seems to be the case, but isn't expressly stated, is that it seems as though the first time limit was missed by the charterers for their counterclaim, but they still then got their submissions in after in the extended period that they were allowed to, and the owner's argument was effectively that because they hadn't applied for the extension before they missed the initial time limit, the effect of the words must be, any extension to the above time limits must be applied for before expiry of the existing time limit. That use of must be was so imperative as to actually disqualify them from being able to extend the time period for producing documents or producing their submissions and indeed submitting them.
The tribunal, however, took a very different view. It seems like the tribunal was of the view that, that they made 2 points. Firstly, that any provision, or they clearly noted that any provision leading to the severe consequence of time barring a claim must be clear and unambiguous. And in the circumstances, it seems like the wording of the clause wasn't that clear and unambiguous. And then the tribunal also said that the rule itself had clarified and outlined the consequences of late submission. And in this case, as you said, since the charters did file their submissions within the deadline set by the arbitrator, the counterclaim couldn't be considered time barred.
Yeah, exactly. And to be honest, if you were on for charterers and you'd lost that argument, you would be livid. I think, as you say, and as the arbitrators found, you need something much clearer than this to say, if you do not submit your document within this period of time, you lose the right to do so. That it would be, it would be a serious infringement of the normal conduct of arbitration if someone was to lose a right entirely to bring a claim, or to bring a counterclaim, or to defend a claim on the basis that a small extension was not requested and not granted. Particularly, I think, if you consider that the principles governing arbitration generally, the fact that it's something which is by consent of the parties, and the general approach to arbitration, the idea that if you miss a deadline by such a narrow period of time, that you lose the entire right to bring the counterclaim or to have your case heard, I think would surprise most arbitration practitioners. And I think the tribunal clearly made the sensible call on this one.
I mean, worth a shot in any event. I think it was an argument that was legitimately run by the owners in any event.
Yeah, I mean, why not argue? And to be honest, we have clarity from this award as well. So helpful all round. I think no need to dwell on it. And we can move on to the actual speed and consumption dispute. And the key part here, for me at least, was the question of whether or not the whole discussion around speed and performance had to be sent to a third party rather than the arbitrator. It's almost a jurisdiction question. Is the arbitrator entitled to make a finding on speed and performance, or does the clause prohibit the arbitrator from doing so and require some other venue for the dispute to be heard?
I recollect from for the award that the parties have indeed agreed by means of clause 57 that in case a dispute arose between the parties regarding the speed or performance of the vessel during a particular voyage, the parties would have to appoint a mutually agreed weather routing company to analyze the vessel's performance, and the findings of this mutually agreed weather routing company would be final and binding.
Yeah, and I do think this is quite an interesting point for whether it's practitioners or people working in an in-house role in the shipping market, because you see these clauses often, and I think there is a tension between what you would normally do if you have a speed and consumption dispute, or perhaps what we normally see when there's a speed and consumption dispute, which is parties speaking to their club or instructing lawyers and saying, hey, can you look into this for us? What's the next step? Can we appoint an arbitrator? This decision clearly says no. If the charter states that where you're considering a breach of speed and consumption warranty, then you have to go to a mutually agreed weather routing company to analyze the vessel's performance, and those figures are final and binding. It's an interesting point to have in reserve. The other point that was raised here, which I thought was an interesting one, is that charterers' claim, it seems, was one that they raised in off-hire as well as under the speed and performance warranty. And presumably, charterers would have made the argument that this clause should only bite on the damages claim, on the speed and performance, on the breach of warranty claim, not on the off-hire claim, which wasn't strictly a claim for breach of warranty. It's a claim for off-hire because there's a defect in the vessel in some way or some other failure, depending on the off-hire clause in this case. Mm-hmm. But obviously the tribunal here said, no, even if it's framed as off-hire, it still falls under this requirement to go to a independent third party expert.
Yes, I think that the spirit of the clause is essentially to avoid the need to refer the disputes to arbitration and simply, try to find a commercial dispute by a commercial resolution to the dispute by referring the matter to a mutually agreed weather routing agency.
I mean, from our perspective, that's just a useful thing to have in reserve. If you're looking at one of these cases and you're thinking, should this be arbitrated? Then you can know in the back of your head, London Arbitration 923. That is some helpful authority. It's not binding precedent, but it is helpful guidance on how you should be treating one of those clauses that says that all of the speed and performance issues go to a weather routing company whose findings will be final and binding. There is some clear guidance out there that's going to be upheld, and the arbitrator will stay away from making a decision before the weather routing company has made theirs.
Yeah, we don't know all the details, but probably the charters didn't have the time, or the parties didn't have the time to refer the dispute to a mutually agreed weather routing agency, and perhaps owners commence arbitration proceedings before the parties were given the chance, so that they had the possibility of making this counterclaim and just went ahead.
I think it probably helped owners' argument here that the clause did set out the names of 3 different weather routing agencies that could be used, because otherwise you'd be in a situation where it would almost be an owner's gift to say, well, we're not going to agree to the weather routing agency. Whereas here there was some clarity around what charterers had to do and who they had to use, who they had to appoint in order to get the resolution that the clause, or get the resolution in the manner that the clause was requesting it. So yeah, look, we try and keep these London Arbitration Awards reasonably punchy on the podcast, and not go into the weeds in too much detail, as sometimes Luke and I can be guilty of. But I think we've actually covered a couple of interesting points reasonably effectively there, Miguel.
It's been really great to take part. I hope it's not just the last. It will be the first, but not the last.
Yeah, exactly. Hope to have you back on the podcast. We'll sign off in that case, and we'll wish all our listeners a good day. And please do follow, share, whatever you're supposed to say about getting people to subscribe to your podcast. Please do those things. Press whatever button is being shown to you by your streaming service. And we will be directly on your feed every week with another case. Thank you very much to our listeners. Thank you again to Miguel for joining us on the podcast. We do appreciate it. Take care and see you next week.